Hi, my name is Joseph Blocher. I'm a professor of law at Duke Law School, where I'm also the faculty director of the Center for Firearms Law. And I want to talk to you today about the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruen, which announced a new and fascinating test for adjudicating Second Amendment cases. So one of the major jobs of constitutional doctrine, especially when it comes to constitutional rights, is to decide which kinds of regulations are permissible and which kinds are not. In Bruen, the Supreme Court announced a very different kind of test for adjudicating Second Amendment claims. So if a gun regulation is challenged as being inconsistent with the Second Amendment, what courts do now is first ask, does this regulation fall within the plain text of the Second Amendment? And if so, is it consistent with this nation's historical tradition of weapons regulation? Now, just looking at that test and the two parts, you might think, oh, there might actually be some hard questions in there, right? So if we're focusing on the plain text of the Second Amendment, it's just 27 words, what constitutes an arm for Second Amendment purposes, right? Most people would think, okay, handguns fall within. How about machine guns? What about nuclear weapons? What about poison gas? What about nunchucks? Things that aren't, modern weapons in the same kind of way. That's a lot of hard questions. How about who constitutes the people under the Second Amendment? Does that include people who lack citizenship? Does it include people who are incarcerated? Does it include the mentally ill? Does it include 18-year-olds? Does it include 11-year-olds? Lots of hard questions at the plain text prong. Even when you get through that, though, then you have to say, well, is the challenged law consistent with this nation's traditional history of gun regulation? And that's a hard question, too, because technology and society have changed in so many ways. In 1791, there weren't really any laws on the books prohibiting you from taking a loaded handgun into the cabin of an airplane, right? There weren't a lot of laws that directly touched on the connection between guns and domestic violence. We have those kinds of laws today. So drawing those kind of analogies across time is both fascinating and a real challenge under the Bruen test, and I think is actually an interesting sort of window into the way that originalism can work in other areas of constitutional rights as well.